Let's start with a simple question. What happens to your money, your house, your car, and everything you own when you're no longer here? That's what estate planning answers. Think of estate planning like writing instructions for your life's biggest game of pass it on. You're deciding who gets what, when they get it, and how they get it. But here's the thing, it's not just for rich people with mansions and luxury cars. Whether you have $1,000 or $1 million, estate planning matters. Imagine Sarah, a 35-year-old teacher. She owns a modest home, has some savings, and drives a 5-year-old Honda. She thinks, I don't need estate planning, I'm not wealthy. But when Sarah unexpectedly passes away without any planning, her family spends 2 years and thousands of dollars in court just to figure out who gets her house. Her nephew, who she was closest to, gets nothing because legally, everything goes to her estranged brother. This could have been avoided with just a few simple documents. Estate planning sounds complicated, but it really comes down to 4 main documents. Think of them as your life instruction manual. First, the will, your final wishes on paper. A will is like leaving a detailed note that says, here's who gets my stuff. It covers everything from your house to your grandmother's wedding ring. But here's what many people don't know, a will only covers things in your name alone. Let's say you and your spouse own your house together. When one of you dies, the house automatically goes to the surviving spouse, the will doesn't even come into play. But if you have a car in just your name, that's where your will takes over. Second, the trust, the smart money manager. Think of a trust like hiring a responsible friend to manage your money according to your exact instructions. You put your assets into the trust, and you choose someone called a trustee to distribute them according to your rules. Here's a real example. Mark wants to leave money to his 16-year-old daughter, but he doesn't want her to blow it all on a sports car the day she turns 18. So he creates a trust that says she gets money for college immediately, then receives the rest in portions at ages 25, 30, and 35. The trustee makes sure this happens exactly as Mark wanted. Third, power of attorney for finances, your money guardian. This document chooses someone to handle your money if you can't. Maybe you're in a coma, maybe you have dementia, maybe you're just too sick to pay bills. Your chosen person can access your bank accounts, pay your mortgage, and handle your finances. Without this, your family might have to go to court and ask a judge to appoint someone to handle your money. That takes time and costs money when your family is already dealing with your illness. Fourth, healthcare directive, your medical voice. This document has 2 parts. First, it chooses someone to make medical decisions for you if you can't. Second, it tells everyone your wishes about end-of-life care. Do you want to be kept alive on machines if there's no hope of recovery? Do you want all possible medical treatment, or do you prefer comfort care? These are tough questions, but answering them ahead of time saves your family from having to guess what you would have wanted. Why I'll do it later is a dangerous game. Let's be honest, most people avoid estate planning because they think they have plenty of time. I'm young, I'm healthy, I'll get to it next year. But life doesn't wait for your schedule. Consider Tom, a 42-year-old contractor with 2 young kids. He keeps saying he'll get his estate planning done after his next big project. Then he has a heart attack while mowing the lawn. Because he never got around to it, his wife faces a nightmare. Without a will, state law decides everything. The kids inherit Tom's half of everything, but they're minors, so a court has to appoint a guardian to manage their money. Tom's wife can't even sell the house without court approval because the kids technically own half of it. What should have been a simple process becomes a year-long legal mess costing thousands of dollars. Here's another reality check. If you have young children and you die without choosing guardians, a judge decides who raises your kids. They'll try to choose family members, but it might not be who you would have picked. Your party-loving brother might get chosen over your responsible sister simply because he's older or male. And if you think your common-law marriage protects your partner, think again. In most states, if you're not legally married, your partner gets nothing. Everything goes to your parents or siblings, even if you've been together for 20 years. The truth is, estate planning isn't really about death. It's about protecting the people you love from unnecessary stress, expense, and confusion during an already difficult time. One of the biggest myths about estate planning is that it's expensive. Yes, there are costs upfront, but they're much smaller than the costs of not planning. For a basic will, you might pay anywhere from $150 to $600 if you use an online service or simple attorney. A basic trust might cost $1,000 to $3,000. The healthcare directive and power of attorney documents usually cost a few $100s each. So, for a complete basic estate plan, you're looking at somewhere between $500 to $4,000 depending on how complex your situation is. Now compare that to what happens without planning. Probate court, that's the legal process for distributing your assets without proper planning, typically costs between 3% to 7% of your total estate value. On a $300,000 estate, that's $9,000 to $21,000 in fees, plus months or years of waiting. One woman shared that settling her father's estate without proper planning cost $15,000 in legal fees and took 18 months. The same estate with proper planning would have been settled in 30 days with minimal costs. Think of estate planning like buying insurance for your car. You hope you never need it, but when you do, you're incredibly grateful you have it. Let's talk about the mistakes that turn estate planning from helpful to harmful. Mistake number 1. Forgetting to update beneficiaries. John divorced his wife 10 years ago but never updated the beneficiaries on his 401k and life insurance. When he dies, guess who gets $200,000? His ex-wife, not his current wife and kids. The beneficiary designation overrides what his will says, so his current family gets nothing from these accounts. Always check your beneficiaries after major life changes, marriage, divorce, births, deaths, or if you simply change your mind about who should inherit. Mistake number 2. Thinking joint ownership solves everything. Many people think putting everything in both spouses' names eliminates the need for estate planning. This works fine when the first spouse dies, but what happens when the surviving spouse dies? Without a will, everything goes according to state law, which might not match what the couple wanted. Plus, joint ownership can create problems. If you add your adult child to your bank account to help with bills, legally they own half that money. If they get divorced or sued, creditors might be able to take your money. Mistake number 3. DIY estate planning gone wrong. Online wills can work for simple situations, but they're not one-size-fits-all. Maria used an online service to create her will, but she didn't understand that in her state, handwritten changes on a printed will make the entire will invalid. When she crossed out her brother's name and wrote in her sister's name, she accidentally invalidated the whole document. Mistake number 4. Forgetting about digital assets. We live digital lives now. What happens to your Facebook account, your Bitcoin wallet, your family photos stored in the cloud, or your online business when you die? If no one knows your passwords or has legal authority to access these accounts, they might be lost forever. One family lost access to thousands of family photos stored in Dad's iCloud account because no one knew his password and Apple wouldn't give access without a court order. Include digital assets in your planning. Create a secure list of your accounts and passwords, and make sure your executor knows how to access it. Mistake number 5. Not talking to your family. Estate planning isn't just about documents, it's about communication. If your family doesn't know your wishes or where to find your important papers, even perfect planning can fail. Tell your loved ones who your executor is, where you keep important documents, and what your general wishes are. You don't need to share every detail, but they should know the basics. Not everyone's estate planning needs are the same. Let's look at some special situations. 1. If you have young children. Your biggest concern is probably choosing guardians. This isn't just about who loves your kids, it's about who can actually raise them. Consider the potential guardian's age, health, financial situation, parenting style, and location. Also think about money. Life insurance can help ensure your children are financially cared for. If you leave a large sum to young children, consider a trust that pays for their needs growing up and then distributes the remainder when they're mature enough to handle it. 2. If you own a business. What happens to your business when you're gone? Can your spouse run it, or should it be sold? Do you have business partners who need to buy out your share? Business succession planning is crucial and often requires special legal documents beyond a basic will. 3. If retirement accounts make up most of your wealth. 401ks and IRAs have special rules. They pass directly to your named beneficiaries regardless of what your will says. But here's a crucial detail: if you don't name beneficiaries, or if your beneficiaries die before you do, these accounts might end up going through probate court. Also, inherited retirement accounts have different tax rules for spouses versus children or other beneficiaries. Poor planning here can cost your family thousands in unnecessary taxes. 4. If you have family members with special needs. Leaving money directly to someone who receives government disability benefits might actually hurt them by making them ineligible for assistance. Special needs trusts allow you to provide for a disabled family member without affecting their government benefits. 5. If you're unmarried but in a committed relationship. The law doesn't recognize relationships, only marriages. If you want your partner to inherit anything or make decisions for you, you absolutely must have estate planning documents. Otherwise, your family makes all decisions and inherits everything, even if you haven't spoken to them in years. Ready to actually do this? Here's your roadmap. Step 1. Take inventory. Make a list of everything you own: house, cars, bank accounts, retirement accounts, life insurance, investments, business interests, and personal items with sentimental or monetary value. Also list your debts. Don't worry about exact values. You just need a general picture of your financial situation. Step 2. Think about your goals. Who do you want to inherit your assets? When should they receive them? Who would you trust to raise your children? Who would you want making medical and financial decisions if you couldn't? Write down your thoughts. This isn't set in stone, you can change your mind, but it helps clarify what you want. Step 3. Decide on your approach. For simple situations, you're married, have straightforward assets, and want everything to go to your spouse then children, you might be fine with online estate planning tools or a basic attorney consultation. For complex situations, you own a business, have children from multiple marriages, want to minimize taxes, or have substantial assets, you probably want to work with an experienced estate planning attorney. Step 4. Gather your information. You'll need social security numbers, addresses, and phone numbers for everyone you want to name in your documents. You'll also need account numbers for major assets and contact information for financial institutions. Step 5. Create your documents. Whether you're doing this online or with an attorney, be thorough and honest. Don't try to hide assets or leave out important information. Step 6. Sign everything properly. This is crucial. Most states require wills to be signed in front of witnesses who also sign. If you don't follow your state's rules exactly, your documents might not be valid. Step 7. Store documents safely. Keep originals in a safe place like a safe deposit box or fireproof safe at home. Give copies to your executor and tell trusted family members where originals are stored. Step 8. Review and update regularly. Review your estate plan every few years or after major life changes. Marriage, divorce, births, deaths, major purchases, or changes in financial situation. Here's what estate planning really gives you: peace of mind. It's the comfort of knowing that if something happens to you, your family will be taken care of according to your wishes, not according to state law or a judge's decision. Think about it this way. You probably spend more time planning your vacation than most people spend planning their estate. But your vacation lasts a week, while your estate planning affects your family for years or even generations. Estate planning isn't about death, it's about love. It's about taking care of the people who matter most to you, even when you can't be there to do it personally. The hardest part is getting started. Once you begin, you'll realize it's not as complicated or expensive as you thought. And once it's done, you'll wonder why you waited so long. Your future self, and your family, will thank you for taking action today. Don't be the person who says, "I'll get to it next month" for the next 10 years. Your family deserves better than that, and so do you. The question isn't whether you need estate planning. The question is whether you care enough about your family to do it. And if you're watching this video, you clearly do care. Now turn that care into action. Thanks for watching. Kindly like and subscribe.